Good morning, everyone. I'll just commence by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land, pay my respects to elders both past, present, and recognise their continuing connection to our land, waters and culture. I extend my respect to Aboriginal and Torres Strait Islander peoples here today and those online listening and watching. Good morning, everyone. My name's Mick Franco, and I'm here today with my partner, James Matson, who's sitting in the front row. We know a lot more information compared to the session that we did in February, but we don't know everything yet. So today will involve some revision of what we spoke about in February, some examination of what's in the consultation draft regulation, and some crystal ball gazing into what the IRC practice may look like. We don't have all the answers, but the picture is emerging. If I have time at the end, or if we have time at the end, I'd like to flag some what I describe as design issues with this legislation, but nothing that is insurmountable, hopefully. The focus today is on relevant conduct claims. That is the stream of psychological injury claims earmarked for the Industrial Relations Commission for determination where there is a dispute. I'll start off by recapping some of the critical pieces to the legislation which we talked about last time, and then move into the regulation. And then James is going to take you through his views on the IRC practice based on long-time experience practicing in that jurisdiction. So not making it up, but based on real experience. And then we'll talk about the design issues. I extend a warm welcome to everyone here and all the people who are watching and listening remotely. Unfortunately, for those who are listening remotely and watching remotely, it's fixed. I was just going to announce a technical issue, but I'm told that it has been resolved, so I won't say anything more about that. Okay, so let's recap. With these reforms, and I want to stress this, with all psychological injury claims moving forward, we have to look at the definitions to ensure that there is eligibility there to start with before we even think about a dispute. So there is the definition of psychological injury, which is on your screen. That's different. So if it doesn't fit into that definition, that's a red flag. Then there is the causation test. No compensations payable for a primary psychological injury. So that includes all psychological injuries, unless a relevant event or series of events caused the primary psychological injury, and there is a real and direct connection between the relevant event or a series of relevant events and the worker's employment, and the employment is the main contributing factor to the injury. So whenever we get a psychological injury, we've got to look at those eligibility tests, those definitions, the causation test. But perhaps the most important thing is that the conduct, which is the subject of the psychological injury, which caused the psychological injury, has to fall into one of the relevant events as defined. Now, I'm not going to go through the relevant events because we did that last time, but the focus today is on bullying, excessive work demands, racial or sexual harassment. I've put a new relevant event in the last dot point. It's called prescribed death. I won't go into it now. If we have time at the end, I'll go through the definition for you. It's remarkable in terms of the layers of causation to establish eligibility. It's not yet law. It's in the consultation draft regulation. And it just goes to show how easy it is to add new relevant events by popping it in a regulation rather than legislating. Okay, so just to recap, relevant conduct claims, there's very strict timeframes to deal with them. If a claim is made, if it's properly made, we've got 42 days to deal with it. Accept and commence interim compensation, interim entitlement payment, or deny. And if we don't address it within 42 days, it's an offence. Also, if it's not determined within 42 days, the claim is deemed accepted, which means that the conduct is deemed accepted. Dispute proceedings are in the IRC and not in the PIC, and there must be a mandatory review before proceedings can be commenced. And then in the IRC, there's a conciliation and determination process, which James will deal with. Once it's determined by the IRC as to whether or not the relevant conduct occurred, there has to be a certificate of determination and reasons, a judgment. The determination of the IRC is also binding on the Personal Injury Commission in subsequent proceedings that may occur in relation to eligibility. And the worker can't commence proceedings to recover compensation in the PIC until the IRC has determined the relevant conduct. If the IRC determines the relevant conduct has not occurred, then that's it. The claim's at an end. If the IRC finds the conduct has occurred, the decision is issued and the worker must give the decision to the insurer, and the insurer must make a decision within 7 days in terms of paying compensation or not. There may be other disputes. There may be disputes as to capacity, for instance, and that will provoke another dispute notice, and that will go through the PIC. Now, just quickly, the interim entitlement payment, for this stream, provisional liability does not apply. Forget about reasonable excuse for this stream. It's an interim entitlement payment. It's 75% of pre-injury weekly earnings and medical expenses up to $7,500. And once a claim is made and accepted in terms of the claim being properly made, the interim entitlement payment must start as soon as possible, and failure to do so is an offence. The interim weekly entitlement ceases 14 days after a dispute notice, if that is issued, or 56 days after the claim is properly made. So that's the extent of the interim entitlement payment. If the claim is ultimately accepted, there is a back payment required from the date of the claim until acceptance, and it's the difference between 95% and 75% of PIAWE. And also, if there are any outstanding medical expenses the worker has incurred themselves, they have to be dealt with. Okay, that's the revision from last time to set context. We now have this exposure draft regulation, and it was released on the 20th of April. It's a public consultation piece. Anyone can say anything about it to the government through the website, and the feedback, the opportunity to give feedback finishes tomorrow. So if you want to give feedback, jump onto the website and say what you think. Whether or not it'll be considered, that's another question. The regulation has a lot of things in it, a lot of topics. For today, we're just going to focus on the relevant conduct claims. One thing that occurs to me in reading it. It's quite a dense piece of statutory content. What I can see from it overall with relevant conduct claims is that there's a heavy onus on workers to make claims in detail. I query how they'll be able to manage this with or without legal assistance. There's strict obligations on insurers to provide information to assist workers to make claims and to navigate through the system. And I quote, in language the worker is reasonably able to understand. I see a prospect of incomplete claims remaining in limbo because workers cannot navigate the new system for relevant conduct claims, which means no interim compensation will be paid because they don't get to first base. And that will have an impact on financial support for injured workers if they're injured, and of course, the return to work piece. Now, that sort of causes me to hark back on some days long past where there was this notion of claims not being duly made. There's people in the room here who are nodding and they remember that. What does it take to make a claim? There is a claim form, and they have to provide evidence prescribed by 2 regulatory items. The claim form is 11 pages long. It is laden with instructions and definition, many items to check and boxes to fill in. It attempts to capture all manner of information. For relevant conduct claims, the worker must identify the relevant conduct item, the relevant event. So if it's bullying, that box must be ticked. And then they have to provide information. In fact, the regulation says evidence, not information, not particulars, evidence. The word evidence seems to impose a higher bar in terms of the obligation to make the claim. And I think it's a good idea to have a claim form capable of eliciting the worker's narrative relating to the conduct which caused the injury. But I suspect the exposure draft claim form will be quite daunting for a large number of claimants. And that's what informs my comment about claims being incomplete and going in limbo. Now, the evidentiary pieces that are required, clause 42E on the slide, that's pretty basic, so I won't talk about that. But the other one, 42F, talks about additional evidence. The first thing that the worker is required to disclose is details of any proceedings already before the IRC, employment claim proceedings. So case number, details, lawyers. But this only relates to public servants, state and local government employees who have access to the IRC. What the designer of this regulation has omitted is to ask for information about proceedings in Fair Work, for instance, or in the discrimination bodies where private sector employees might have complaints about bullying or harassment. So that's a bit of an omission. I have provided that feedback. I should let you know that the regulation draft was not prepared by CIRA. It was prepared by the Department of Customer Service, I think it's called DCS. I think Treasury might have had a hand in it as well. That's my suspicion. So the additional evidence also requires, as far as reasonably practicable, date, time and location of each incident of the conduct, specific nature of each incident of the conduct, person involved in the conduct, names of witnesses to the conduct, and an explanation of the relationship between each instance of the relevant conduct and the worker's employment. So this requires evidence of those things. Now, if you look at the claim form, there's boxes that can be filled in, but they're not very big. You can attach addendums to the claim form. It can be signed. I guess that can amount to evidence. What is the meaning of the word evidence? I had a bit of a look at this. I looked up the Interpretation Act and the Evidence Act. It's actually not defined. Is it admissible evidence or not? So that's all got to play out. But it's more than just particulars or information. So bear that in mind. Now, incomplete claims. So if the requisite evidence is not submitted, the claim is not complete. So what must an insurer do? Within 3 days, they must contact the worker and again explain in language the worker is reasonably able to understand that the claim is incomplete and cannot be progressed until it is complete. The action the worker must take, that the worker is only entitled to the interim compensation payment from the date the claim is complete, not the date of injury, and how to obtain a claim form if they haven't got a claim form. Assuming the claim is properly made out and is complete and is valid, if I can use that word, within 7 days, the insurer must start paying the interim compensation entitlement, give the worker written information, again, in language the worker is reasonably able to understand, notice of the interim payment that has started, an explanation of how it's calculated, when it's going to end, and the fact that the insurer has to decide to accept or reject the claim within 42 days. While deciding, the insurer has to pay medical costs under the new test, reasonable and necessary, and if injury management applies, if Chapter 3 applies, an injury management plan must be prepared. Now, that's a lot of information to give to the worker, and then in the next few slides, there's more information. I would suggest that it would be a good idea for the designers of this to perhaps issue standard items of correspondence, so all insurers in the system, not just in the scheme, but in the system, sing from the same song sheet. That has not been a traditional phenomena. Insurers have had their own correspondence. Different insurers have different ways of informing workers about obligations and entitlements. Okay, we're now up to the bit about disputing liability. These are the matters that the insurer must consider. Date, time, and location of each relevant event. Now think about this. If we're dealing with bullying over, say, 3 or 4 years, and there's many events, let's say there's 20, 50 events, they've got to think about each one. The worker's account of each relevant event, the witness account of each relevant event. If the relevant event involved the conduct of another person, their relationship with the worker, available medical and health information, information held by the employer, including audio and video, reports about the relevant event made by the employer, so internal employer reports, or reports made by the union, police, Safe Work, Fair Work. Now, bear in mind, if the employer has made a report, that might have been done under legal advice, and it may be privileged. And then finally, information provided by the worker. Now, in the list, in the regulation, that actually appears last in the list of items. I wonder what that means. I wonder how important information from the worker might be. I would say it is important. Then there also has to be a notice of the back payment if the claim is accepted. So that's on the slide there. I won't go into that. That's fairly self-explanatory. But if you can't work out the back payment because you don't have enough information, then you've got to tell the worker that, and you've got to explain what steps you're going to take to get that sorted out. Disputing liability, the Section 78 the clause 37 in the regulation requirements still apply for section 38 notice, but here are some additional requirements. You've got to tell the worker has a right to review. You've got to say that the review is mandatory before you can go to the IRC or the PIC, and you've got to give contact details for the IRC. Internal review, getting to the end of my bit. The internal review is interesting as well. Within 2 business days, so you've disputed at this point, within 2 business days of the request for an internal review on a dispute for a relevant conduct claim, the insurer must give the worker information about how the review will be conducted, a timetable for the review, the name and contact details of a person who can be contacted concerning the review. Then the internal review must be conducted by an internal reviewer who has relevant experience in the subject matter of the decision under review, was not substantially involved in the decision under review. Wonder what that means, substantially. They perhaps can have some involvement, but not that much. And here's the one that cracked me up when I read it, is more senior than the person who made the review, or who made the decision under review, is more senior. What does that mean? Age, experience, pretending to be knowledgeable. There's a lot of people that pretend to be knowledgeable. I don't know what that means. The internal reviewer may request additional information from the worker and the employer and must consider the additional information that is submitted. Then we get to the internal review decision. The decision must be a concise and readily understandable statement of reasons for the insurer's decision, and the issues must contain the relevant information in the regulation about dispute notices, and must refer to each section of the legislation that informs the decision. So that's at the review. We assume the review upholds the dispute. The review decision replaces the previous review decision. On that note, I will hand over to James, and then I'll come back at the end.
Thank you, Mick, and welcome, and lovely to see everyone. As an employment lawyer, it is sometimes difficult for us to understand why the current workers' comp scheme operates the way it does. We're just wired differently. A few years ago, after reviewing a number of Section 11A cases, I said at a conference, to overcome what I saw was very generous decisions in the area of Section 11A. In other words, they just weren't, the 11A defence wasn't getting up. Perhaps matters relating to these site claims should go to a real court. And I suggested the Commission. Now, not that the government listened to me or that it was my idea, but here we are. And we're 1.5 months to go before we land in the Industrial Relations Commission. And where we're at right now is we've got no practice note. There's no forms. The indications that I hear are that nothing will change, but I think something will need to change potentially. How much and how far is unknown, and I'll express some views about that shortly. But what we know is that consultation with industry stakeholders by the Commission will be occurring in June. So maybe the last week of June, practice notes and forms will come out. So that's how close we're running to the line. What will it all look like? So I'm going to go through what are the legal tests now in the new legislation and try to give an insight as to how this might be approached by the Commission. In talking about how it might be approached, the Industrial Relations Commission of New South Wales, until very recently, hasn't had a bullying jurisdiction, a sexual harassment jurisdiction. That has existed in the Federal Fair Work Commission, and I see no reason why the Industrial Relations Commission won't depart from that. So a lot of what I'm saying is pulling lessons from the federal scheme, which I think will strongly influence the way the New South Wales Industrial Relations Commission deals with it. Now, the definition of bullying is a very traditional definition that we see both in the federal scheme and by the regulator Safe Work. And it means where, in relation to a worker, an individual or a group of individuals repeatedly behave unreasonably towards the worker or a group of workers. Now, rather odd is that what I don't see in that definition is the words that we're very accustomed to that follows. And the behaviour creates a risk to health and safety. Because there may be behaviour that's unreasonable that just really doesn't cause any harm or distress. But those words aren't there. What does that mean? It might mean that this jurisdiction isn't concerned about that because you're dealing with an injured worker. I find it impossible to conceive that the Commission, in analysing whether conduct's bullying, won't be thinking about whether the conduct is of that level that it creates a risk to health and safety, because that's intrinsic in what is bullying. And that comes out when you look at repeatedly behave unreasonably towards the worker. It's intrinsic in that element. The other thing that isn't in the definition is reasonable management action. And that deeply concerned me on a first read. Now, there's a new section 11A, which is in far better terms than what exists currently, in that it's unhinged from the formal aspects that it needs to be in relation to disciplinary action, redundancy, and particular matters. It just says reasonable management action taken or proposed to be taken by the employer in relation to a worker. So it's not hinged on those elements. But Section 11A doesn't feed into Section 8A. You've got to look a little bit to work out how that applies and how that gets in. And there's a section, Section 280AH, so buried away. And I dare say that's going to cause some difficulties for workers because it's not going to be easy to find. But that says that the Industrial Relations Commission, when considering the matters, may have regard in determining whether the conduct of the claim was or was not relevant conduct, whether it was reasonable management action taken by the employer. So the Commission's got to consider it. Thank goodness, because that's really important, because and sometimes it's called the exception to what is bullying. It's not so much an exception, but it's an important qualification which reinforces that bullying conduct must of itself be unreasonable, and reasonable management action can never be bullying. And it also emphasises the right of management to take reasonable management action in the workplace. That's a right employers have, and it's a very important right that can't be ignored. So when we look at the way it's likely to be determined, Fair Work Commission decisions are quite clear that unreasonable behaviour is behaviour that a reasonable person, having regard to the circumstances, may consider to be unreasonable. So it's not a worker's perception alone that determines it. It's the reasonable person, and it's a balanced assessment. It's a balanced assessment looking at all the circumstances. And also what we're talking about is a type of behaviour. that persistent unreasonable behaviour, not one event, not two events that are separated in time and have no connection. And what we do see in respect of reasonable management action is that reasonable management action, at least, is defined in the new legislation. It's section 8F, to mean action taken in a reasonable way, and that is reasonable in all the circumstances. So I always use this as a classic case, a manager that patiently had been trying to get a worker to do work in a particular way. The worker was always resistant and argumentative because their way was better. Whether their way was better or not, the employer has the right to say, this is the way we're doing it. And in a meeting to explain it's really important that you do it this way, the worker went off again and the manager yelled and said, shut the F up. Brought a bullying application, and the commission said in all the circumstances, it was reasonable management action to yell, to emphasise your point after a long period of trying to get the worker to listen. That's a balanced assessment. And I think what we're not going to have is the 11A approach of today, where that imperfection of yelling founds a workers' comp claim. So what we're going to see is this type of language coming through the case law. Management actions don't need to be perfect or ideal. Tick. A course of action may still be reasonable action, even if particular steps aren't followed or there are flaws along the way. Just got to look at the whole picture. Reasonable management action can't be irrational, absurd, or ridiculous, but it might not be what one would do, provided it's reasonable, it's okay. And even if you significantly depart from established policies or procedures, if the departure is reasonable in the circumstances, it's reasonable management action. So the days for searching for imperfections are over. As an employment lawyer, I say hallelujah. It's a great thing. Excessive work demands. No case law on that at the moment, but I think that's going to be a hot area of development. The legislation says that excessive work demands in relation to a worker means work demands that are beyond the requirements expected of a worker's role. That's not a tick and checklist against the PD. Employment law recognises that roles have flexibility, recognises that there is some expectation inherent in all jobs we do, that you step up to the plate, you go that extra mile when circumstances require it. So it's not going to be, it's not in my PD, it's an excessive work demand. There's also the element that the work demands need to be repeated or persistent. And that's where the word excessive, I think, is quite important, because what we're looking at is some work patterns, some work circumstances that are unsafe. Unsafe in the sense that it's giving rise to a psychosocial hazard, which is why I have the code on the side, because I think there's going to be a lot of leaning into safety to understand that. And then the demands have to not be reasonable in all of the circumstances. So in other words, again, we're looking at the big picture here to form a balanced assessment of whether or not there is that relevant event. I dare say when we look at whether work demands are excessive, we're going to be looking at some of the federal case law that deals with whether 40 hours, 45 hours, 50 hours a week are unreasonable hours. But we've got to be careful that the hours you work are just one part of what might be the work demand. So whilst that law might be useful, we've got to look a little bit deeper. Usefully, Section 8M sets out some of the things that need to be considered. regulations can prescribe other relevant matters. I didn't see any in my look. Mick's confirmed there's none as yet. So at the moment, what you're looking at is what are the patterns. I think I should say usual rather than unusual. What are the usual patterns of work in the industry? What's the nature of the worker's role, level of responsibility, their employment arrangement? Just because you are in a senior role won't mean you can't be subject to excessive work demands, but the Commission will be having regard to the nature of role that it might mean it comes with an inherent level of demands. Compensation a worker is entitled to receive. Again, that's looking at whether you're paid a salary and a healthy salary, whether you get overtime and penalties in respect of the work you do. Just the mere fact that you get it won't mean it's not excessive work demands, particularly if it's persistent, repeated, and it's having that psychosocial impact. And regard will be had also to, for example, industrial agreements and arrangements that apply. Hard to understand how a history of repeated or serious contraventions is relevant, because the fact you've got those contraventions might not really impact on what's happening in respect to that particular worker at that particular time, but it's something that they've prescribed, and it will be something we need to have regard to. Racial harassment. Probably not more needs to be said about this. It's a fairly simple definition. What I will say is that it's talking about more of that direct discrimination that we as employment lawyers are used to, that in all the circumstances, the behaviour that's occurred, is it done because of the person's race? Sometimes actions occur and it's got nothing to do with that person's race. And what will be key there is what is the reason? And I expect, consistent with practice, that would mean the relevant decision maker or the relevant person who engages in the conduct will need to hop in the witness box and say why they did it. Sexual harassment, I think, is the other area, along with bullying, where we're going to see a lot of activity. It adopts a very traditional test, but like bullying, it drops an important element, which is that the unwelcome sexual advance or request for sexual favours or the unwelcome conduct of a sexual nature, that the conduct occurs in circumstances in which a reasonable person, having regard to all the circumstances, would have anticipated that the other person would be offended, humiliated or intimidated. That was left out. But there's another section that says, in determining whether the conduct occurred, you've got to apply an objective test, and Parliament says that that objective test will require that consideration. So again, I'm seeing an alignment with the employment law concepts, and I think that will fall into the approach the Commission takes. And there's lots of case law at the federal level and in the anti-discrimination jurisdiction in New South Wales that deal with sexual harassment. So a bit of insight on what the tests are and how they're going to be applied. Now we're in the Industrial Relations Commission. Now I get told at the moment that the way things work generally in the PIC is that it's a front-ended system. There's no extra evidence when you get to the Commission. There's no cross-examination. There's a limited hearing. Sounds quite alien to me. In the Commission, things are different. You run a case in the ordinary way. So you get to put on more evidence. You get to cross-examine witnesses. You get to have a full hearing. Everyone gets their day in court. Now, I suspect it's going to be business as usual. There may be some changes, but I suspect it's going to be business as usual. I'll explain what that is and I'll explain why. Now, the Industrial Relations Commission for 120 plus years has been built around conciliation and arbitration. What will conciliation involve in the context where the insurer and the reviewer have said, no relevant conduct, we're not giving you insurance? Conciliation may be an opportunity to convince the insurer that they're wrong. It may be an opportunity to convince the worker they're dreaming. It may, and this is going to be really interesting, and I think there needs to be more development and thought in this area, lead to a discussion about separation. If you're saying all these events that weren't bullying are really impacting you, is this the job for you? The insurer might not want to have the discussion, but the employer might want to have a discussion about, well, what can we pay you to leave? Will the Commission entertain that? The Commission's entertained those discussions for 120 years. That's going to be a really interesting field in which you operate. The employer might not want its workers to give evidence in a contested hearing and might have an interest to pay something. Really, really interesting area, conciliation. What's that going to look like? In the IRC, as I said, it's adversarial. It's not a formal court, so it moves quickly. There's no rules of evidence, but it does allow cross-examination of workers, of managers. And I think that's going to be really critical in this jurisdiction. And if that's taken away, I think it's a problem for three reasons. Firstly, whether there has been bullying or harassment will turn on a proper assessment of people in the witness box. You can't pick up things on the paper. You can get a certain picture, but it's not the complete picture. Secondly, and this has been recognised by the Federal Commission, in particular by Deputy President Sams, is that the brush of accusing a manager or a colleague of being a bully or a harasser is significant and profound. If findings are made of bullying and harassment against a manager or co-worker without a hearing, that would be a travesty. And it would have deep consequences and impacts on work relationships, careers, and the like. Thirdly, given we've gone to this new scheme to more rigorously test whether there is a relevant event, to bring more balance in the system, I think the confidence and the effectiveness of the new system will be impacted if decisions are made on the papers. And I think there will be many parties aggrieved without a full and proper assessment. Now, the last thing I want to talk about before handing back to Mick is something that applies to the state system and local government entities. It doesn't apply to private sector employers. And it doesn't apply to private sector's employer because their bullying and sexual harassment jurisdiction is a little bit different to the state system. If you can access the state system because you're in New South Wales government entities or framework, you can bring a stop bullying application or sexual harassment application and seek compensation of up to $100,000. And there's a possibility that you can read the provision at the moment that says if you do that first and you win and you get your compensation, you can afterwards decide to bring a workers' comp claim and you're not barred from doing it. You bring the workers' comp claim first, you can't then go to the anti-bullying or sexual harassment jurisdiction. So there appears to be an anomaly there. That will need to be worked through as to whether it exists or not. But an interesting issue arises. If in some forum the dispute of bullying has been dealt with by the Commission and they've made findings, Or let's say for a private sector employer, they've gone to the Fair Work Commission and there's been findings. Are we going to have another hearing? Or are we going to stick with the findings that have already occurred? There will be issues of estoppel, res judicata that's going to arise. These are things we're going to need to work through. But that's something that I certainly, and Mick certainly sees on the horizon here, because people are ventilating these claims elsewhere, and there may be decisions out there that are not favourable to one or maybe both parties, and how that's applied. That's how I think it's going to work in the IRC, but we'll find out in 1.5 months.
Thanks, James. So just on that last point, I touched on that when I talked about the item in the regulation, the draft regulation, where the worker is required to provide details of prior IRC proceedings. I think that will be amended to bring in the obligation to provide details of prior proceedings in other forums, such as Fair Work. So we've got a few minutes still. To conclude, I just wanted to identify what we see as some design issues with all of this. It's certainly not an exhaustive list, because the more you think about it, the more problems can be envisaged. So I said at the beginning that there is the prospect of claims being incomplete and being in limbo. That will have a financial impact and a medical impact on people who are injured. And it certainly has a significant impact on impeding a mutually acceptable return to work. So that needs to be thought about, how that's dealt with. James touched on what the implications are for a finding of relevant conduct, a finding of bullying. How is that then going to impact on the return to work of the worker and the worker's interactions with co-workers and superiors? If there is a finding of relevant conduct in the form of bullying, that'll be in a decision, a written decision. That is then an opening for other regulators to become involved. And what I see potential for is CIRA in its employer supervisory jurisdiction, not as supervising the insurer, but in supervising the employer on policies and procedures that deal with, anti-bullying, return to work, and of course, Safe Work New South Wales. It may open the door for those entities to storm into the employer. It's not so much a problem for the insurer, but it certainly is a potential problem for the employer. James talked about the jurisdictional overlap, the stop bullying, stop sexual harassment in the IRC, employment claims. How does that then fit with the relevant conduct claims? How's the IRC going to deal with this? Is it going to be separate divisions? Is one division going to have regard to what the other division did on the stop bullying? Or do we have to repeat everything? I also see an overlap with traumatic claims. What if the causal events, the relevant events, can be characterised both as relevant conduct and traumatic? When I say traumatic, violence, criminality, serious injury, death, and vicarious involvement in those matters. What if a worker makes more than one claim? Relevant conduct and traumatic, 2 claims. What if the injury in the claim evolves from relevant conduct to traumatic, or vice versa? With bullying, it's repeated conduct. It's more than one incident. It can be many incidents that can constitute bullying. What if some of the incidents involve threats of harm and violence? I know where you live. I'm going to get you. I'm going to take you out. Things like that have been known to be said in workplaces. On the claim form, they've got to tick a box, relevant conduct or one of the other relevant events. What if they tick 2 boxes? How do you deal with that? What claim pathway applies? Provisional or interim entitlement payment? 12 weeks or 42 days? PIC or IRC? What if the worker makes more than one claim? How should insurers approach this? What information should be given to workers? Because we've got to give them a lot of information. What information should be given to employers? I'm not asking you to give me answers to all of those questions, but they're real questions that need to be thought about in the design of this 2-pronged system. There's probably much more. The more you think about this, you think, oh, geez, that could be a problem. So I'll leave you to think about those things. But before we finish, I just want to circle back to the definition of prescribed death. It's quite fun. The death is not fun, but the definition of this relevant event it's a beauty. Prescribed death for a worker means the death of a person who is in the worker's care. If, and here's a series of causation points, the person dies as a result of a traumatic incident, that's defined in the legislation. There is a real and direct connection between the person's death and the worker's employment. That's a variation on a typical compo causation test. The person was under the immediate and primary care of the worker at the worker's workplace when the traumatic incident occurred. The relationship between the person and the worker was pre-existing, ongoing, and close at the time of the person's death. And the relationship was a requirement of the worker's employment. That's a lot of causation layers to establish a prescribed death. I asked someone yesterday, someone of importance, what's that aimed at? Where did that come from? And I was told it was involved a teacher. So maybe a student died under their care. But what about doctors, nurses, aged care employees? You could make a long list. But to get to establishing a prescribed death, there's lots of layers of causation. So it's not a lay down misere to prove, far from it. So I just thought I'd say that. I didn't want to talk about that at the beginning because it's not really part of the talk. Come back up, James, and we're happy to take some questions. Are there any questions online?
Got quite a few online, so I don't know whether you want to.
Okay, so to those online, what I did last time was I diligently went through the questions in the ensuing weeks and gave answers. So I will do that if we can't deal with them today. But can we take one from the room first? Will Murphy.
Thank you. What are the repercussions of it being or not being a prescribed death?
That last bit that I did, I haven't really thought about it. Well, if it's not a prescribed death, then there's no claim. No, I don't think so. And it's not a relevant conduct claim. So today we're talking about relevant conduct, bullying, excessive work, harassment. Prescribed death does not fit into that. So it's not an IRC matter. It'll be a PIC matter, and it'll be dealt with in the usual way. Can we take a question from home?
Yep. So for not complete claims, is there an entitlement to medical expenses? Noting we expect quite a lot of claims to remain incomplete for some time. Does this mean workers will have no access to treatment?
That is correct. The only rider I put on that is that under Chapter 3 that deals with injury management, there is an ability to pay medical expenses in the guise of injury management. That's their section 50 something of the 1998 Act. But in terms of eligibility for compensation under section 59 and 60, if it's incomplete, it doesn't get to first base. Can we have any other questions in the room? Marie.
Thank you. This is really for James and you, Mick. In the IRC, how long do the matters generally take to resolve? So what would be the approximate time frame?
Depending on their workload and whether there's any urgent industrial disputes, you could get a conciliation between 2 to 6 weeks. Then if that doesn't resolve it, directions tend to get made at that time or very, very soon after, like a matter of hours, not weeks. And evidence would have to be put on by the applicant in 3 weeks, employer 3 weeks after that, 1 week for the worker to respond, and then it gets the first available hearing date. This scheme might put a lot of pressure on the system and hearing dates could be pushed out, but I dare suspect the Commission may get extra commissioners. Our experience is within 6 months, matters are dealt with and decided.
Sorry, just a second, Mick. During that time, do insurers still need to comply with the injury management obligations, return to work, all that sort of stuff?
Yes. So, I mean, it's fairly clear in Chapter 3, I think it's section 41, capital A, that says the injury management obligations of Chapter 3 apply, notwithstanding any dispute on liability. Can we have a question from remote?
A number of workers do not have English as a first language and or will not possess the skills to document or evidence continued behaviours, which could very well constitute bullying. What considerations have or will be given to workers who do not possess or know this is what will be required of them to bring forward such matters?
It depends on what body of information is produced by insurers to give to everyone. But with that example, it's pretty hard to imagine how a worker can navigate this system. I have actually spoken to the IRO about this in terms of legal funding through the ILR scheme. It looks like that will be available. Whether it's available at the claim making start of the claim, I don't know. But I think the philosophy of the ILR scheme was that, if a worker requires legal advice to avoid being disadvantaged and loss of entitlements, then the scheme has always been favourably disposed to providing legal assistance. Any other question in the room? Or what about another question from remote?
Yeah, we've got quite a few, so maybe just one more. So,
one more, okay.
Are there any circumstances where interim payments would not be commenced once the claim is complete?
No circumstances. It's mandatory. Yeah. One final bit. There is consultation with the IRC on the design of the practice and procedure. That will be happening, and I'm really pleased to say that I'll be involved in it. So learnings from that will be shared with all of our friends and our clients. Thank you. Thank you very much for coming today. Before I finish, I'd just like to thank Charlotte, who has really helped James and I in terms of the preparation of the slides and making this event run seamlessly. So thanks, Charlie. Thank you, everyone.